Hello everyone, my name is Jeffrey Lynch and I will be your host for this presentation on IRA beneficiary planning. It is one video in a series that I have put together to provide general information to the public about what estate planning is today. In this video, we are going to discuss some key terms related to IRAs, withdrawals of IRAs, and what happens to an IRA account after someone passes away. So first I'd like to talk a little bit about what's going on today. And many studies have shown that there was a mentality that was accepted by two generations, the baby boomers and the war babies, with respect to saving inside of retirement accounts. The war baby generation is approximately 73 to 82 years of age. And then there's kind of a subcategory of the baby boomers called the early boomers, which is the generation right behind the war babies. And those two generations have amassed large savings inside of individual retirement accounts. It's estimated that $12 trillion will go from the war babies to the boomers and to the younger generations, and then there will be an even larger $30 trillion transfer from the early boomers to the younger generations, and much of that money will be in qualified accounts and individual retirement accounts. So it's very important that you understand either how your IRA will pass to your beneficiaries, or if you think that you'll be a beneficiary of an IRA, how that will be inherited by you. So the first term we're going to talk about is required minimum distributions. As you deposit money into an IRA, you receive the tax benefit of not having income tax assessed against that money. Therefore, your account builds on a tax-deferred basis. But we said deferred, not tax-free. It's deferred because at some point the government wants to have the ability to tax it. That's where the required minimum distributions come in. At age 70 and a half, the IRS requires the owner of an IRA to start taking distributions so that it can be taxed. Let's look, for example, at someone who turns age 70, reaches that age 70 and a half mark. Currently, the table for the calculation on your required minimum distribution says that at age 70, you take the entire amount that is inside of your IRA and you divide it by 27.4. So that gives you the amount that must be withdrawn. For instance, if you have a $500,000 retirement account, divide that by 27.4, your required minimum distribution at age 70 is going to be $18,248. That represents a 3.65% withdrawal from the account. Now, if your financial advisor and you are able to work together to build the account balance back up to $500,000, congratulations, that's great. And let's say you're able to do that every year over the course of 10 years, while taking your required minimum distributions. You can see that at age 80, you still have $500,000 in your account, but the number that you divided by has gone down. Currently, someone who's 80 years of age will use the number 18.7 to divide their entire portfolio by. That represents a $26,737 required minimum distribution, which represents 5.35% of the portfolio. So you can see as you get older, more money is going to need to be withdrawn under the IRS rules. So now that we've discussed a little bit about required minimum distributions with respect to the owner of the account, we need to talk a little bit about required minimum distributions and other distribution patterns for inherited IRAs. So after the account owner dies, what happens? First and foremost, if you are married, your spouse can take your IRA and deposit it into their account and treat it just like their own. That's what most spouses do. There are a couple other options, but the majority of spouses take those IRA funds from their deceased spouse and put them directly into their own. Then, after the second spouse passes, or if a single person passes, there are 7 main beneficiaries of an IRA. There is a beneficiary of one person. There can be multiple people. There could be no beneficiary designated on the designation form, and it would pass to the estate of the person who passed away. It can be left to charity. It can be left to a living trust, or it can be left to an IRA beneficiary trust. I'm going to discuss the different beneficiaries and what happens to those accounts and what kind of risks are associated with naming each of those different beneficiaries. So there's one more very important term that you need to know with respect to passing an IRA account to the next generation, and that is spendthrift protection. So a spendthrift is someone who is typically bad with money. That could be a minor. That could be someone who's addicted to drugs or alcohol or gambling, or someone who just makes bad decisions with money. After you pass away, typically these monies are deposited into trusts that have spendthrift provisions so that the trustee of the trust can look over the money and make sure that distributions to the beneficiaries are truly for their betterment, that they're not used to pay off whimsical debts, that they're not used to fuel drug habits or gambling habits, but rather for the health, maintenance, education, support, and betterment of the beneficiary. Now, spendthrift provisions only apply to the next level beneficiaries. They do not apply to grantors of trusts. It's not like someone can deposit $500,000 into a trust, declare themselves the beneficiary, and then save that money from a bankruptcy. It doesn't apply to the grantors of a trust. It only applies to the second level qualified beneficiaries of a trust. So why is this concept of spendthrift protection important with respect to inherited IRAs? Well, there has been a recent change in the law, and it was done through a Supreme Court case, Clark v. Remaker. And the best way to show you how the laws have changed is to look to what led up to the decision. So the question that was posed in the case was, can a creditor attach a claim to a retirement account? Now, during the build-up period, while the owner is still alive, the person who's putting the money into the IRA, while they're still alive, the money's inside of those IRAs and 401ks is protected by federal law. But once the owner passes away and those monies are inherited by someone, then the question is, are those still creditor protected? Well, first let's look at what the Arizona law says. So current Arizona law says at ARS 33-1126, money benefits or proceeds and their exceptions. Under B, it says any money or other assets payable to a participant in or beneficiary of a retirement account, whether the beneficiary's interest arises by inheritance, designation, appointment, or otherwise, is exempt from all claims of creditors of the beneficiary or participant. So under state law, if someone inherited an IRA, then it was protected from the creditors of the beneficiary. So in a bankruptcy situation, those monies would not be able to be used to pay off the debts of the beneficiary. That's what Arizona law says. Well, that was challenged, and it went all the way to the Supreme Court, and the Supreme Court had to decide, should those inherited monies be protected from creditors, or should they be available to pay off the debts of the beneficiaries? Well, the Supreme Court decided that an inherited IRA doesn't serve the same social purpose as the protections that are afforded to the person who's depositing the money into the IRA. So the original owner of the IRA is putting money in there to save for retirement, and there's a social interest in making sure that that person has money for retirement, so it's protected from the creditors. But the Supreme Court said it doesn't have the same characteristics once it's been inherited. So inherited IRAs are no longer creditor protected when they are inherited by an individual. That's the key thing that you need to know, is if you put as your beneficiary of your IRA on your beneficiary designation form your children, some other relative, someone that's not related to you, but that the money is going to go to them individually, that money is no longer protected from the creditors of that beneficiary. That's the big difference that Clark v. Ramaker changed, that it created. So now let's talk about how we can apply our two important terms, required minimum distributions and spendthrift provisions, to each different possible beneficiary of an IRA. So from this point forward, we are not going to be talking about spouses anymore. This is only going to be after a spouse has inherited the money, or if it was a single person, this is the possible beneficiaries for these IRAs. First, we're going to talk about naming one person as the beneficiary of your IRA. So you get your IRA beneficiary designation form and you write down one person on there. Could be a child, niece or nephew, other family member, somebody that's not related to you, whoever you wanted to receive that money. You put it down on your IRA beneficiary designation form. Now, that person has to follow a set of rules established by the IRS. And the rules go like this. If the account owner who passed away had already reached age 70 and a half and was taking required minimum distributions, then that beneficiary can either take the distributions based upon the remaining life expectancy of the deceased owner, or they can take it based upon their own life expectancy. So if we go back and remember from our previous slide, someone who is 80 years of age that has $500,000 in their account, they have a life expectancy of 18.7 years. That's the number that we use to divide the entire amount of money that's in the IRA. That leaves us with a required minimum distribution of $26,737. Now, if the beneficiary is, say, 45 years of age, the IRS has determined that their life expectancy is 38.8 years. So if we use the beneficiary's life expectancy, we take the $500,000, divide it by 38.8, which only means that the required minimum distribution is $12,886. That's a considerably smaller amount than the $26,000 if we use the life expectancy of the deceased owner. Why is that important? Because we want to keep as much money as possible in these IRA accounts because they're growing on a tax-deferred basis. It can be an incredibly large savings to keep these monies in there as long as possible. Now, if the beneficiary had not reached age 70 and a half, there's a different set of rules. In that case, the beneficiary, after the owner has died, either has to take the money out within 5 years of the death of the account owner, or they have to take it over the beneficiary's life expectancy. Most beneficiaries obviously take it over their own life expectancy because taking the entire amount over the course of 5 years will incur large tax bills, large income taxes. Now, what's the big thing here? There is no spendthrift protection when you name an individual as the beneficiary of your IRA. So if that person ends up with a judgment against them from a car accident, from some other kind of lawsuit, or they get themselves into trouble with debt, they end up in bankruptcy, After you've passed away, those inherited funds can be used to pay the creditors of the beneficiary. So the next two possible beneficiaries of an IRA are either a charity or your estate. I'm not going to go into the intricacies of designating a charity as the beneficiary of your IRA because there are many pitfalls that can occur, and the rules are very complex. So if you are planning on leaving money in your IRA to a charity, please contact an attorney, contact the charity itself, contact a professional that can help you navigate those rules. In some instances, an estate can be named as the beneficiary of your IRA. That will be if no beneficiary is named on a beneficiary designation form. It automatically goes to your estate. Or if someone that you've named on the beneficiary designation form has passed away before the owner did, then that too would trigger the estate being designated as the beneficiary. Now, if the owner of the account has reached age 70 and a half, is already taking required minimum distributions and passes away, and the estate ends up as the beneficiary, then the estate can continue to take the required minimum distributions based upon the account owner's life expectancy, or they have to take it over the course of the 5 years. Now, if the owner of the account has not reached age 70 and a half and their estate ends up as the beneficiary, then the monies must be taken out within 5 years of the death of the owner. So again, it goes back to our discussion about stretching out the IRAs and utilizing life expectancies. If this is a possibility, you need to speak with your financial advisor, with an estate planning attorney, to make sure that we take advantage of all the tax deferrals that we can. A good estate planning attorney should review those beneficiary designation forms with you to make sure that all your affairs are in order. Now, spendthrift protection. If your estate ends up as the beneficiary of your IRA, there is no spendthrift protection for whoever is going to be the inheritors of your estate by law, either by your will, a devisee, or by law as an heir. They will not have creditor protection. So what happens if you put more than one person down as your beneficiary on your beneficiary designation form? Let's say you have 2 children. You name each of your children as the beneficiaries of your IRA. Now we have a multiple person scenario. The IRS says that by default, with respect to the required minimum distributions, the oldest beneficiary's age will be used to calculate the required minimum distributions. So if you have one beneficiary that is 45 years of age, and then you have a second beneficiary that is, say, 40 years of age, you can see where the 40-year-old is going to have to use the 45-year-old's age and their life expectancy for the calculation of the 40-year-old's required minimum distribution. Well, that kind of handcuffs the 40-year-old because they could have more growth, which means more tax deferral, which means more money if they were able to use their own age. Now, the IRS allows for each beneficiary, if the account is set up either prior to the death of the owner or by the end of the year after the year of the death of the owner, if it's set up into a separate account just in the name of that individual beneficiary, then they're able to use their own individual life expectancy. Now, what does that create? It creates a duty for those beneficiaries to get that done. Sometimes it happens, sometimes it doesn't. And if we get to the end of the year after the account owner passed away and it doesn't get done in that year, then the 40-year-old is stuck, taking the required minimum distribution of the 45-year-old. Now you can imagine where that's an even larger difference if the age difference is bigger between the two beneficiaries. You have one beneficiary that is, say, 50, and another beneficiary is, say, a grandchild who is 25. It's possible that the 25-year-old could have to use the required minimum distribution of the 50-year-old and miss out on a large amount of tax savings. Again, naming multiple beneficiaries with respect to spendthrift provisions, there is no spendthrift protection. If you name multiple individual beneficiaries, no spendthrift protection. If they end up with a judgment against them, if they end up in bankruptcy, the inherited monies can be used to pay off those judgments. So finally, let's talk about naming your living trust as the beneficiary of your IRA. Living trust, also known as the family trust, the revocable trust, revocable living trust. There have been many clients that I've met with who had it suggested to them that if they wanted spendthrift protection, right, the same spendthrift protection that was done away with Clark v. Ramaker, that spendthrift protection is still available if a trust has the correct provisions that establish the spendthrift protections. And most attorneys write into their living trusts spendthrift protections. So the connection that's been made is, well, if you want to continue to have spendthrift protection, name your trust as the beneficiary of your IRA. When that occurs, there are a few specific traps that can affect RMDs. The first is naming individuals as the beneficiary of the trust, right? So in this scenario, we have the trust named as the beneficiary of the IRA, and then we have individuals named as the beneficiaries of the trust, right? We're going to interchange that term beneficiary. But in that instance, if there are multiple beneficiaries of the trust, okay, then the oldest person must, their age is used for the required minimum distributions. Now, when we had multiple beneficiaries earlier, there was a little safety net where after the account owner passed away, the IRS allowed for those multiple beneficiaries to split the account into shares and use their own ages for the required minimum distributions. If the trust is named as the beneficiary of the IRA, and there are multiple beneficiaries of the trust, those beneficiaries do not get to utilize that same safety net. Okay, the IRS does not allow multiple beneficiaries of a trust to separate the IRA account into shares for their benefit and take advantage of the required minimum distributions based upon their own ages. Okay, it has to be based upon the oldest beneficiary of the trust. Many trusts, living trusts, also have the ability to accumulate money. Okay, as part of the spendthrift protection and as part of the benefit of the trust, say for a minor, the trust is allowed to accumulate money inside of the trust. Now, that's pretty standard on most living trusts. If a trust has that provision, then the IRS can go in and look past the named beneficiaries of the trust and see anyone who might become the beneficiary of a trust. So if the last surviving grantor of the trust is 80 years old, they've got their IRA pointed at their trust, you know, the trust is the beneficiary of the IRA, and let's say they have a sibling, and that sibling is 78 years old. But the trust has named their kids, who are 40 and 45 years old, as the beneficiaries of the trust, right? Super confusing, right? Well, here's what the IRS can do. Instead of taking the 45-year-old's age, right, who's the oldest of the named beneficiaries of the trust, if the trust can accumulate money, they can hypothesize what would happen if both the 45-year-old and the 40-year-old were no longer living, then who would inherit? And if the next person to inherit is the 78-year-old sibling, guess what? They get to use the 78-year-old's life expectancy rather than the 45-year-old's. So now you have a 45-year-old and a 40-year-old who are both living, who are both named as the beneficiaries, but the required minimum distributions are being based on the 78-year-old's age, right? Huge disadvantage. Secondly, let's say that the trust names the 45-year-old and the 40-year-old as the beneficiaries, but there's also a small percentage that goes to a charity. I know we didn't discuss the charities, but what happens is the government treats it as though there's no named beneficiary. And all of the money from the IRA would need to be distributed within 5 years. Even though the 45-year-old and the 40-year-old are alive and well, because there's a charity named, everything has to come out within 5 years. Huge disadvantage, right? Lose out on all that possible tax deferral and all the gain associated with it. So while naming the trust as the beneficiary will provide the spendthrift protection that we've been talking about, that we were looking for, there are large downsides with respect to the required minimum distributions. And that's what brings us to our discussion of a new trust that I am currently using to maximize both spendthrift protection and required minimum distributions, and that's called an IRA beneficiary trust. So the IRA beneficiary trust is going to allow your beneficiaries to take advantage of maximum spendthrift protection and the largest stretch with respect to required minimum distributions. And the best way to show you this is through an example. So in this example, we're going to have a family that at one time consisted of a mother and father and 2 children, Tom and Mary. The father is the first to pass away, and the father names the mother as the beneficiary of his IRA. And in his IRA there was $400,000, and in Mom's IRA there was also $400,000. So the father passes away and the mother inherits the entire amount, and she is able to continue to do well inside of the accounts and has $800,000 at the time that she passes away inside of the individual retirement account. So we're going to go through the different scenarios of the beneficiaries that she could leave. So let's say Mom names Tom and Mary as the beneficiaries of her IRA. On her IRA beneficiary designation form, she puts them down and they individually inherit the IRA. If they do it correctly, they can set up separate accounts and they can use their own ages for the required minimum distributions. That's if they do it correctly. If they don't, then Tom's age would be used for calculating the required minimum distribution, and Mary loses out on that tax savings. But there is no creditor protection. I think we've covered that thoroughly. If Mom names the living trust as the beneficiary, and then she names her children as the beneficiaries of the trust, we've talked about the pitfalls that could possibly come up. But let's say there are no pitfalls, there's no sibling, and everything works out so that Tom and Mary are the ones who will inherit. Mary is stuck using Tom's life expectancy for the required minimum distributions. And in the next slide, I'm going to show you what that means on a hard numbers example. But if Mom names the IRA beneficiary trust as the beneficiary of her IRA, then the kids get the best of both worlds. The traps go away. There's maximum creditor protection. Tom and Mary will have the longest possible stretch for their required minimum distributions, which means they'll have the largest possible tax savings associated with an account like this. All right, let's look at how this trust is used to benefit the family. We have $800,000 that mom has inside of an IRA that she leaves to the two children, Tom and Mary. When structured properly, $400,000 is allocated to Tom and $400,000 is allocated to Mary. Now, assuming a 4% gain year over year, Tom's account, using his age for the required minimum distributions, would equal a total distribution of $922,900. But Mary, using her own age, at age 40, in her own life expectancy for required minimum distribution calculation, means her total distributions are going to be $1,039,015. That's a $116,000 difference just by having these things set up correctly, while also providing for the maximum possible creditor protection. If either Tom or Mary is sued and they have judgments against them, or they're going through a bankruptcy, these monies will not be used to pay off those debts. So you can see where it's extremely beneficial for them to be able to get through this disruptive bankruptcy or the judgment that they have against them, come out on the other side, and still have a nest egg to restart their lives. And that's what we're protecting. People make mistakes, accidents happen, but we try to make sure that it doesn't ruin someone's life, that they're able to start over and try to get back to a point where they have a long and happy and healthy life. Well, thank you for watching my presentation on IRA beneficiary trusts. If you have found this information beneficial to you and you find yourself in a position where you'd like to speak with an attorney regarding your estate plan and how an IRA beneficiary trust might benefit you and your family, please give me a call. My office number is 602-840-4101, or you can email me at jeff@jdlynchlaw.com, or you can visit my website where I have a section there that you can provide me with your email and telephone number, and I would certainly get back to you as soon as possible. Just remember that an IRA beneficiary trust is one more protection that you can set up for your family, and it's part of an overall comprehensive estate plan that includes living trusts and last wills and testament, powers of attorney, and all the basic documents that a family needs to make sure that their affairs are in order. I'll leave you with the tagline for my law firm. Life is a journey that begins and ends with family. We take that to heart here, and we love to represent great families in the state of Arizona who want to make sure that their families are protected as well. Thank you.